We're here for sentencing today.
Your Honor, we've reviewed the paperwork. I have no corrections or anything to make to the paperwork. I don't think you're going to see a lot more of Mr. Coleman moving forward. I have one ask of the court as well. He has been staying at a hotel since this started. It's been very financially taxing. I know the court probably requires the victim in the case to appear and ask for modification of the no contact order. I don't know if probation reaches out to them or there's a process for seeing about that, but we're hoping that there could be some movement on that. I don't know if he can live there for the next year. I don't see how he could financially do that.
I have a couple of concerns before we get to that. One is, why is his version of the offense today so different than his version of the offense on the day of the actual incident, and very different than the multiple witnesses who watched this incident and the video that's involved?
You're asking me, Your Honor? Well, I don't really
you probably need to talk to your client about that, because I'm very concerned.
Okay, I can speak with him about that, Your Honor.
I'll pass this while you do that. State of Michigan versus Chanel Parker, case number 21 FB 1919. State of Michigan versus John Coleman, case number 24 FB 1186, recall.
Certainly, this is for the people.
Good morning again, Your Honor. Sam Bernstein with and on behalf of Mr. Coleman, who's with me here.
State your name, Mr. Coleman.
Yes, John Earl Coleman, Jr.
Thank you. All right, Mr. Bernstein.
So I did just watch the video, Your Honor. And I did, I'm looking at what he said here. I mean, of note, I think importantly, he says, I'm sorry he was hurt by my actions. I hope we can mend our differences and move on. I acknowledge my actions in this situation. I frankly, I do see the video there. In defense of Mr. Coleman, there are self-defense elements there. I think what he's saying is he took it too far. And his guilty plea that he gave is an acknowledgement that he did take it too far, that he should have been the more mature one, and that he should have, stopped when he had a chance, and acknowledging that he did escalate the situation from where it was. But,
Mr. Bernstein?
Yes, Your Honor.
He says, he moved in front of me to fight as he was coming in aggressive to punch me in my face. And I believe the video shows him chasing someone.
Yeah, no. The guy does, it's unambiguous. He does approach Mr. Coleman aggressively, and then Mr. Coleman chases him. And this is after Mr. Coleman is giving his significant other a hug, and the victim puts his hands on Mr. Coleman. Mr. Coleman jumps back in shock, and then the victim walks to Mr. Coleman, and it's not really unambiguous the way he's walking. It is provoking, it is aggressive. But Mr. Coleman should have stopped from there.
And that's all.
Yeah, I have it right here. Okay. Yes. And there are real elements of self-defense. I think where the self-defense claim breaks down is, Mr. Coleman's an adult, this is with a kid, and he had an opportunity to de-escalate and he didn't take it. He should have taken that opportunity to de-escalate. And I think that's just very clear on him as the adult. He should have stopped.
How old is the victim in this case?
How old is he?
He's 28 years old.
And the other part I have a question about is, was there a stabbing and another stabbing of the same victim by Mr. Coleman?
Like a second one other than the day of?
Yes.
No, not that I know of.
There was not a previous one it was mentioned in the police report, I think it was.
Oh, I'd have to look at it.
Your Honor, I have quite a few, I guess, past files and on base, but it would take me a minute to kind of go through and see if one of these might be referring to something like that.
It doesn't even look like it was from this county.
Okay.
From what I recall reading last night. I'm trying to find it again. Previous incidents. Guy advised that John stabbed him with a knife in the stomach 2 years ago in Inkster, Michigan.
True. That's not true.
Oh, an 18 case?
I don't know. I'm just reading on page 9 of 10. So these are the things that are giving me a whole lot of concern. Obviously, I have not, and I'm not privy to the video because courts don't get that unless a trial happens or someone provides it to the court. So based on what the police report said versus what the video showed versus what you're telling me, and what he was saying was a very distinct difference. And in addition to that, I'm seeing in here this previous stabbing in the stomach that is alleged in this report, which obviously is going to give me some grave concerns about this family and how things are going.
And I do, one second. And I do recognize in his statements, I mean, and it's common with a lot of people in this situation, there is an effort to make themselves look better than what they did. I mean, I can't hide that from Your Honor. I mean, it's a common thread in these situations. And I mean, if there is a case out there that's unresolved or something, it's gonna have to look that one up and resolve it. I don't have any like information on that though. I don't think he ever went to court for anything.
All right, Ms. McDuffie.
So, Your Honor, I had the same concerns that the court had. I think that one of the items that just seemed a little bit odd to me was how coincidental it was that Mr. Coleman would have just been walking around with a pair of garden shears in his pocket or on his person. That just seems like it's sort of odd. And knowing that there is some animosity, at least on some level, between these two individuals, it's concerning to me that Mr. Coleman may have been anticipating some sort of altercation or fight and came prepared for it. And knowing that wielding a weapon of that type is obviously, there's no way that I can interpret any of those versions of events as being something that would have called for him using that, wielding, brandishing, and using that in that manner. So even if Mr. Nunley was the initial aggressor in some way, I just don't see that. So I do agree with Mr. Bernstein that this is a case where Mr. Coleman is probably trying to present himself as being a more taking some responsibility off of him, and that's my concern. Obviously, moving forward with sentencing, is that he truly has some insight into not only his actions here, but this household situation is obviously very contentious and unhealthy. And along with that, I'm going to object at this point to the bond request because I don't have any information that would suggest that that's something that is agreed upon. But I also have additional concerns about what the environment is like in this household after Ms. Wilson has reached out. So that's all I have to say.
Well, I'm going to play a little bit of a devil's advocate here, Ms. McDuffie. Mr. Coleman is much older and, is the adult, but they both are adults at this point. And Mr. Coleman, is dealing with someone who's very young and spry versus, himself. And maybe he does feel like he needs to have some protection. And, his story is that he had been outside gardening, and sometimes that happens. So having said that, you say you can't see an instance when that would be the case. it doesn't get past the issue that it sounds like they should not be in each other's company. That's a part of the problem, right? They just shouldn't be around each other because there is a volatile situation going on. But the defense, which was waived, was self-defense, which is probably how we got down to from an aggravated assault down. I mean, from what was initially charged, assault with a dangerous weapon, to an aggravated assault, because there was a potential self-defense. I don't know. I don't know if he didn't show or what happened, but we're down here with a misdemeanor now. So I say that to say that there may be an instance in which he feels as though the only way he can protect himself is with a weapon. So that's what his claim is. Do you not see that as a possibility?
Well, let me be clear. I didn't say that I don't see any scenario where he would happen to have the shears on him. I felt like it was a little bit odd, considering just the circumstances, the background of the sort of conflict. And I don't, in the report at least, there's no reference to him engaging in some sort of gardening activity. It says that he remembered that he had garden shears in his pocket, and that he, after this issue, the pictures that are shown in the scene, I can see why the gardening would be necessary, I guess, looking at the photos of sort of the background there, but it didn't suggest that. What I was saying was that I don't see a scenario where, under anybody's version of events, the sort of attack with that weapon would have been called for and necessary. So even taking Mr. Coleman's account of events as true, I just did not see going for somebody in a stabbing motion with that type of tool. If that's what I didn't see.
I see.
Okay. I don't. But all of that said, and I'm trying to figure out if I should. In terms of, was Your Honor also referring to the bond request when you questioned what I was saying earlier, or just the factual basis of this incident?
The factual basis, because I'm really trying to wrap my mind around them, so that I can figure out what is the best result here. These types of situations are the most dangerous, because if we give them an opportunity to be back together, the scenario can happen again. And I'm extremely concerned if it's happened before, and I feel like I don't have a definitive answer to that. I see that Mr. Coleman has been nodding his head and denying that the previous incident happened, but it is referenced in the police report. So I just need to have a better understanding of that. I feel like I can't make an informed decision without that information.
Yeah, if the temperature's too hot right now, I mean, it's maybe best to let it keep cooling down, and maybe some sort of facilitated discussion down the road is more appropriate for the parties to see if they can live together, than him just driving home right now. I mean, I want everyone to be
safe. Ms. McDuffie, you mentioned something about contact by the victim advocate. Is there something you were able to share now about that?
If we could approach really briefly, Ron.
Yes.
you have to go out. I'm going to talk about his.
We are back on the record in the John Coleman matter. Mr. Coleman, I've heard from everybody besides you today.
Okay.
Is there anything you'd like to say, Mr. Coleman?
Yes, I would, Your Honor. Let me first start by saying I do bear the responsibility of that incident. I have reached out to his mother to tell him that I'm sorry for what took place. Since I wasn't able to tell him in person, I conveyed that through his mother. She said she told him. As I stated in my letter, I would like to mend our differences and try to move on. And that's why the condensed story wasn't the long version.
Okay. I'm not sure I know what you mean by condensed versus wasn't the long.
Yeah, when the probation department sent me the packet to
Mhm.
fill out,
Okay.
that last page said, if you need more room, take another sheet of paper and add it to, your version of the story.
Okay.
So I tried to keep it short and sweet. Not that I tried to slant it in my favor, although it sounds that way. And if it's taken that way, that's just the way I wrote it. But I only listed so much of the incident, if you can understand what I'm trying to say.
Mhm. Yes, I can understand. Not
Thank you.
necessarily, and I agree, but I do understand what you're saying.
Okay.
Well, sir, you've heard my concerns. I've been very clear about what they are. Most importantly, my job is to try to make sure everybody remains safe. And right now, I'm not sure that people feel safe. There's a lot of work that needs to be put in before everybody is ready to be reunited as a family. Blending families is very challenging in and of itself. And when you have people who have these types of, well, there's animosity, and it's not just from that day. It sounds like it's from a long time. And the two of you are like oil and water right now. And I'm afraid, that would be an easy way to put it. I'm afraid it's more like ticking time bombs. And I'm afraid somebody's going to get hurt. Now, you're saying you didn't stab him in 2018. He apparently believes that you did because he told the police that. That's the only way it would get into a police report. So if someone thinks you stabbed them and there's been no repercussions for it, that in and of itself is going to be a problem because people feel like they haven't received the justice that they deserve over certain situations. You want to say I'm sorry, and he feels like it's a huge problem. So this is what I'm going to do in terms of the sentence. It's the sentence of the court that you serve 365 days in Washtenaw County Jail. Credit for 3 days served. 362 of those are suspended. So you don't have to do any additional jail time unless you don't follow the orders of this court. You're on probation for 18 months. Fines and court costs in this particular case for a total of $525. You're to meet with probation when and where directed, including any and all home visits. You need to complete the anger management program with Community Corrections. They have a test that you need to take. If they find that you don't meet their qualifications, then you must complete the PATS program, and probation will tell you about that. There's no contact with Guy Nunley until you have at least finished those particular programmings. No assaultive or threatening behavior towards him or anyone else. You're to submit to, pay, and be responsible for random drug and alcohol tests as requested by the court, probation, police, or treatment provider. No use or possession of alcohol, marijuana, illegal drugs, paraphernalia, and no being in the presence of anyone carrying or using those or firearm components, ammunition, or dangerous weapons. We're going to do a review in this case in 60 days on November the 12th, 2024. That'll be at 10 o'clock a.m. before me on Zoom again, sir. And I hope everything is going well at that time. Hopefully you've begun the PATS program or the Community Corrections program, whichever one it is that you're going to be doing. The Community Corrections program does not cost you anything, and it's free. The PATS program is online, but it does cost. Do you have any questions about your sentencing, sir?
Yes, just one aspect of it.
Yes.
You said be in contact with my probation officer if
Right.
I'm to have family meeting, or not meetings, but visits. Is that what you're saying?
No, I didn't say anything about family visits. I
Okay.
said that you cannot have any contact before your next review, at least. And hopefully you will have your classes done by then, so we can start to talk about whether or not the family can begin any reunification. And the mom will have had a chance by then to give her input on whether she wants that or doesn't want that. And the son, if maybe he knows that you've done some type of programming, might be more amenable to it. But as of right now, we don't have that, so it's no contact. Okay. Now, what you and his mom choose to do off-site when he's not around is there's not a no contact between you and her. The no contact is with God. Okay.
I understand.
Do you have any questions, additional questions, sir?
No.
All right. You're going to need to reach out to the probation department after 9 o'clock tomorrow. I'm going to give you the phone number. Okay.
Okay.
And I'm sure that Mr. Bernstein has it, but 734. And anybody else on the call that might get referred to probation needs to write down this phone number, 734-483-7336.
Okay.
Mhm.
All right, you're all set. So
Thank you, Your Honor.
scenario. I hope things get better. So thank you.